Self-managing a rental property in California is completely doable. I want to say that clearly before we get into anything else, because this video is going to cover some real legal territory, and I don't want that to read as a scare tactic. What I want to do is walk you through the specific habits and decisions that keep self-managing landlords out of trouble. Not theory, the actual practical stuff, because landlords I see run into serious legal problems almost never did something obviously wrong. They had gaps in process and documentation and how they handled the specific situation. And those gaps got expensive. I'm Candace, I manage properties in Orange County. Let's go through this. Screening tenants legally. Tenant screening is where a lot of self-managing landlords create exposure without realizing it. Usually not because their criteria are unreasonable, but because of how they're applying them. California's fair housing protection are broader than most people know. The federal list, race, color, national origin, religion, sex, familial status, disability is the floor. California adds source of income, sexual orientation, gender identity, immigration status, and primary language, among others. What you can screen on: income, credit history, rental history, prior eviction history. Apply those criteria in writing and apply them the same to every applicant, and you will stay out of trouble. What landlords cannot ask in California in a tenant application, and what you should be asking instead. California fair housing law prohibits screening decisions based on race, national origin, religion, sex, familial status, disability, source of income, sexual orientation, gender identity, and immigration status, among others. What you can screen on: income of roughly 2.5 to 3 times the rent, credit history, rental history, and prior evictions. What you cannot do is ask about immigration status, reject someone for having a housing voucher, that's Section 8, or apply different thresholds to different applicants. Write your criteria down before you start taking applications and apply them in the same order to everyone. Note the specific reason for every denial. Proper paper trail is your protection if a decision ever gets challenged. The documentation habits that actually protect you. If there's one thing that separates landlords who stay out of legal trouble from landlords who don't, they write things down, not because they're anticipating a fight, just as a matter of operating professionally. A signed move-in inspection with photos, dated and completed before the tenant takes possession, written acknowledgement of every maintenance request, a paper trail on any communication that relates to rent, lease terms, or the condition of the property. California law does not resolve disputes based on who seems more credible. It resolves them based on evidence. Your documentation is your evidence. The landlord who did everything right but can't prove it is in the same position as the landlord who didn't. The one document California landlords skip that costs them at move-out every single time: a signed move-in inspection report with photos, dated and completed before the tenant takes possession and signed by both parties. Without it, any damage dispute at move-out defaults to the tenant's favor. There's no baseline. Your recollection of the unit's condition on move-in day is not documentation. This is the single most protective document a self-managing landlord can have, and it takes about 30 minutes to do correctly. Most landlords who skip it do so because the tenancy starts fine and it doesn't feel necessary. And then it always feels unnecessary until it isn't. Partial rent and the trap most landlords don't see coming. This one catches self-managing landlords off guard because the instinct makes sense. A tenant is short 1 month, they offer you $800 of the $2,000 owed. Taking something feels better than nothing, so you accept it. The problem: accepting partial rent in California without a written reservation of rights can be treated as accepting partial performance for that period. That doesn't necessarily end your right to the balance, but it can mean serving a new notice, which restarts the clock and costs you time. The fix is simple. If you're going to accept a partial payment while still pursuing the balance, do it in writing. A short notice, even a text stating that you're accepting partial payment and that this doesn't waive the right to the remaining amount that you legally have a right to. That one sentence preserves your options. Accepting partial rent in California, here's what it does to your legal options if you don't do this first. Accepting partial rent without a written reservation of rights can be interpreted as accepting partial performance for that rental period, which may affect your ability to pursue a 3-day notice for the balance. The fix is a simple written statement. You're accepting the partial payment. This doesn't waive your right to the remaining balance or your legal remedies. That's it. Text, email, written notice. The format doesn't matter as much as having it. The landlords who run into the most trouble here are the ones that accept partial payments informally across multiple months. By the time they try to act, the pattern looks like it's an informal arrangement, not an ongoing default. When a tenant stops paying, what do you do and when do you do it? Non-payment is the most common, serious situation self-managing landlords face, and the order of operations matters more than most people realize. Start with communication. A direct professional outreach in the first couple days resolves most situations. The tenant usually knows that they're behind. Sometimes it's a timing issue that gets sorted out quickly. You don't have to skip this step because the legal process exists. If communication doesn't resolve it, serve a 3-day notice to pay rent or quit, and serve it correctly. The amount has to be exact. The method of service has to be documented. The day count starts the day after service, not the day of. And if any of that is off, the notice is invalid and you start over. If the 3-day notice period expires without payment or communication, you can proceed with an unlawful detainer. California's formal eviction process, if you've ever been through it, this is worth bringing in an attorney. Don't do this on your own. The procedural requirements are specific, and a single error in the filing extends the timeline by weeks. How long does an eviction actually take in California? Here's what the timeline really looks like. If everything goes correctly, valid notice, proper service, clean filing, an unlawful detainer from filing to judgment usually takes about 5 weeks. That's the smoothest version. What extends it is a notice with the wrong dollar amount, improper service documentation, a defect in the court filing. Each one of these can mean starting over a step. Each one adds weeks. The landlords who move through this process fastest are the ones who slow down on each step and do it right. The ones who rush are almost always the ones who end up starting over. Self-managing in California doesn't have to be a legal minefield, but it does require knowing the rules, applying them consistently, and having the documentation to back up what you did. None of that requires a law degree. It just requires good habits and the discipline to follow them even when everything feels right, even when you're tempted to take a shortcut. If you're working through a specific situation, a notice question, a difficult tenant, something you want a second set of eyes on, I am happy to help be a resource. That is what I do. See you in the next one.